Shoes. Recorded live.
All right, well, welcome everybody to our regularly scheduled Wednesday night call. It is 8 p.m. Eastern Time. This is Matthew, your moderator. Real quick disclaimer for everyone. This show is a private show. It's not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure. It is not a substitute for legal advice and or guidance by a licensed attorney. This private show is for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communications between the parties. By listening to the call tonight, you acknowledge and agree that you are not a client of Christian Walters. The show recordings are incomplete and void without this notice agreement being attached herein by reference. And a breach of this agreement, upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. And with that out of the way, I am going to turn it over to Christian. It's all yours.
Okay, thanks, Matt. Can you hear me okay?
Sound great.
Okay, we're going to continue on going over the Gilbert's Law Summaries book, Trust. So if everybody has that handy, dig it all out, and we're going to begin on page 6 under section C at the bottom. Trust distinguished from similar relationships. So we're going to be talking about relationships tonight. And I've been finding out that I thought really we were 3 steps ahead, and after asking some people some fundamental questions, I've really found out that we're back on step 1. And it really boils down to that most people think they're more advanced than what they are, and they really need to go back to the basics because they do not understand the basics. They don't understand the 4 elements of the trust. They don't understand the 4 methods of formation and the 4 subgroupings of that. And it really comes back down to how are you going to do anything more advanced unless you can do the basics. If you can't understand what relationships you're forming by going through the elements and finding out which ones you've got, then you're going to be lost. And if you go out and step out and try to do something without knowing the basics, you're going to be totally unsuccessful. So trust distinguished from similar relationships, and I think what we need to do is we need to pay more attention to the relationships that we are signing. And one way to raise a red flag is when you take out that pen and you're going to sign that agreement, you need to be asking yourself right at that point, or in fact even before that, what relationship are you forming at that time? And you should be able to know different relationships and be able to put them in pigeonholes to whatever they are, or at least know what you're doing so you can turn this relationship into a trust, because that's really the goal. So page 6, trust distinguished from similar relationships. Okay, at the top of page 7, number 1, characteristics, not terminology, is controlling, section 27. So similar arrays of rights and responsibilities, including fiduciary duties and obligations, may be found in a variety of other relationships that are in varying degrees, somewhat similar to trust, but which lack one or more of the essential characteristics of a trust. And it is often difficult to discern whether the parties involved intended to create a relationship that is recognized in the law as a trust, because the use of or the failure to use trust terminology is not conclusive of the party's intent. So right there they're telling you right off the bat that, later on in the book it's talking about that no party really needs to know or understand they are forming a trust. So I don't even have to use trust terms. You're just supposed to know the relationship you're getting into, and that's basically how everybody's getting caught up into this whole total mess. And we're really doing trust all the time for the fact that there is no money, can't complete any contracts, can't give any value for consideration. We have colorable contracts today, and if we don't have contracts that we can complete, then what do we have? The fact is that everything has to be a trust then. And everything we are doing when we're thinking we're going to the grocery store, buying groceries or paying the TV bill or the electric bill or whatever, and buying at Walmart or whatever, we're all doing a trust relationship there all the time. It's got to be. If there's no money, it's got to be a trust, period. Forget about debtor-creditor stuff. That's a colorable way, and we've all been tricked into it because we didn't really express the trust. It's being construed, and they're going to construe it to be under debtor-creditor. So God gave you 10 commandments, 10 laws to show you how bad of a sinner you were, but man has given you 63 million plus laws to take everything away from you. So now let's go to the first one we're talking about, number 2, which is bailment, section 28, where the owner of a tangible personal property gives possession, but not title, to another. The relationship is one of bailment. So if the property owner delivers a chattel to another to the benefit the owner or the third party, this may come close to a trust, but it may actually constitute some other form of a relationship. So the guide for distinguishing whether or not it's bailment, the court will first attempt to determine whether the owner intended to pass title as well as possession in assessing whether the recipient is a trustee or bailee. And if the owner's intention is unclear, which usually is going to be the position because nobody knows they're getting into a trust, so I guess it's pretty unclear. An important factor is whether the owner purposes in delivering the chattel could have been affected by a transfer merely of possession. So let's just take an example. So I give someone my pen and I say, I want my pen back after you're done using it. Here we didn't mention any kind of trust terms or anything, but yet the elements are there for a trust, and one of the methods of formation was there. Now, I didn't even know I was forming a trust, say. You didn't know I was forming a trust. Nobody knew a trust was being formed. None of us really understood. But still, that doesn't negate the fact that the elements exist there and the method of formation exists that the law will recognize as being a trust. So a trust was formed, even though we don't even recognize it. So in bailment here, talking about the two types of title, in bailment, the title still is in the bailor, and he would be the same as, say, the grantor in a trust. So the bailor, he still has the title, the legal title to the property, and the possession is just transferred to the bailee, and that would be like the trustee. But it's really not a trust because it's lacking one of the elements. So an important factor is whether the owner purposes in delivering the chattel could have been affected by a transfer merely of possession. Now under B, principal differences between bailment and trust. Number 1, the nature of the property. Bailment pertains only to chattels, and isn't the straw man a chattel? And are we not that? So although a comparable interest in land might be a leasehold, or in other words a lease, a trust may exist with respect to real or personal property, whether tangible or intangible. And remember, your trust res property can be an intangible right, and that's something you can't see, which would be like intellectual property. So number 2, title. The bailor, who is the owner, retains both legal and equitable title. The bailee merely has a right to possession. In trust, legal title is in the trustee, and the settlor does not retain title unless it is an equitable interest retained as a beneficiary, or unless she has served as a trustee, and thereby takes title in their fiduciary capacity. A transaction, however, that would obviously raise no bailment questions. An example, transferor hands her diamond bracelet to transferee, telling transferee to, quote, give this bracelet to my daughter when she returns from Europe. If the transferee is bailee, she merely has a right to possession of the bracelet, and the bailer retains title. If the transferee is the trustee, she has legal title to the bracelet. 3. Transfers. Lacking title to the chattel, a bailee cannot ordinarily convey title to another. That is, even a sale to a bona fide purchaser could not cut off the bailer's interest under common law principles. The UCC changed this rule in certain situations. See sale and lease of goods summary. A wrongful sale of a trust res by a trustee to a bona fide purchaser, however, usually does cut off the equitable interest of the beneficiaries. Under common law principles of transfer of legal title to bona fide purchaser cuts off latent or hidden equities. 4. Income. Rents, issues, profits from the trust res belong to the beneficiary, whereas rents, issues, and profits from bailed chattels ordinarily belong to the bailor. 5. Remedies. Rights between bailer and bailee are usually enforceable at law, although if unique chattel are involved, equitable relief may be appropriate and available. The duties of a trustee are enforceable in equity, and that's where really a trust operates, is in equity. And I was discovered the other day that CCI, or confidential commercial information or trade secret information, which is really the private rights of the substantive man or the real substance, is CCI is a trust relationship where the grantor and the trustee stand in trust in an intended trust conveyance for the benefit of another, the beneficiary. And that, by the way, is Section 336, if you wanted to look that up. So now, agency. An agency often appears very similar to a trust, and the duties and obligations of an agent holding property for a principal are similar to those of the trustee. So the guide for distinguishing, there are, however, various distinctions between an agency relationship with regard to property and trust relationship, and these distinctions are often significant both as possible consequences of the distinction and as possible aids in understanding and identifying which relationship is involved. Number 1, title. A trustee has title to the trust property if an agent may or may not hold the title on behalf of the principal, but the holding of title is not an element of an agency as such. 2, control. An agent is subject to control of the principal, but a trustee is not subject to the control of either the beneficiaries, although they have the power to enforce the trust, or the settlor as such, although the settler's reservation of powers to revoke or amend or direction may give her effective control or some measure of control over the trustee. Now, powers, 39. An agent's authority is limited to what is granted by the principal and tends to be quite strictly construed. In addition to powers expressly granted by the terms of the instrument, the trustee's powers tend to be rather broadly construed. Except as limited by the settler or by law, a trustee generally has powers necessary or appropriate to carry out the purposes of the trust, and under modern view, all of the powers of an outright owner. Now, liability. An agent acting with the scope of his authority and who discloses the agency normally incurs no personal liability. Rather, the principal alone is liable for any contracts or debts thus incurred by the agent. Under the traditional view, the trustee is ordinarily personally liable to third parties for his acts on behalf of the trust. Even when acting properly, he cannot subject the beneficiary or settler to these liabilities without their consent or participation, but does have the right of reimbursement or exoneration from the trust estate for liabilities properly incurred. And a note on that, this traditional doctrine concerning trust has evolved in this direction of recognizing the trust as an entity, with trustees' liability being not personal but representative of the trust, a view that is reflected in many statutes and encouraged by the Third Restatements and the UTC, Section 1010. Termination now, Section 41. An agent's power terminates on death or, except in the case of a durable power of attorney, incapacity of the principal. The trustee's power does not depend on the settler's competence or survival. An example, uncle delivers $25,000 to nephew to distribute to certain of uncle's relatives. Nephew fails to do so prior to uncle's death. If nephew is only an agent, the $25,000 belongs to uncle's estate, and the nephew no longer has power to make distribution among the relatives. If the nephew is a trustee, then the distribution has to be made despite uncle's death. Now the big one, debtor-creditor relationship. And I would read this one over many times, because this is the one we usually get trapped up in. So debt differs from a trust in that although the creditor may have a claim against the debtor personally, the creditor has no interest in a specific property of the debtor, at least until judgment or unless the creditor has a security interest, in which case the rights are still quite different from those of a trust beneficiary. Now, the guide for distinguishing, notwithstanding some obvious distinctions, it is somewhat difficult to tell whether a debt or a trust relationship was intended in its given situation. And a lot of that is because if you didn't know or understand, how would you know what your intent was? But the trouble is, your intent was demonstrated by your actions. So if you acted to form the trust without knowing it, even though you didn't know it, the trust still formed, or the debtor-creditor relationship still formed. So the crucial distinction is usually whether the parties intended to create a relationship with respect to the specific property. For example, transferor hands transferee a bundle of $20 bills totaling $500 and indicates that she wants the money returned at a specific date. If, as is likely, the transferor does not care whether she gets back that particular group of bills or even property directly traceable to them, the arrangement cannot be a trust but is simply a debt, and thus the transferee can repay the transferor any $500, say $100, and is free to dispose of the particular bills received in any way that they really want to. Now that's pretty key right there. That's a key bingo. And I'd mark that because what's happening is there's, in a non-commingled goods or segregation of funds, and you want to see Section 101 for that. So a security interest is an insurance policy, really. If you don't issue the instructions to convert the note, say, in an example where the specific property would be the note in a mortgage closing, convert the note into a trust to pay the debt side, they have insurance that you will pay the mortgage payments by the security agreement. So the UCC-1 filing and the security interest there, the security agreement, is nothing more than insurance to back up the fact that at closing you had the ability to take the note and pay the debt right then and there by expressing the trust. But if you didn't, the bank knew you probably wouldn't. You got caught up into the insurance part of it, which was a secondary contract that took place once you started making the payments to pay off the note over the next 30 years. But how does that affect with this deposit here? Well, if we're going to say that we want specific $20 bills back that we gave totaling $500, the very exact ones, so it would be an in-kind in and the same kind back out. Now we have not commingled any kind of funds. We have a specific deposit, or really a special deposit, or a trust deposit. Special deposit is the same as trust deposit. So if you want to make sure that you're forming a trust relationship under this debtor-creditor relationship, you must make a specific deposit, the special deposit, this in-kind deposit, because if you are not going to, if you specify that they're not to commingle the goods, that you wanted the exact $20 bills back, that's key because that's going to determine that you have a trust. because you trusted this person with the specific property, and you want that specific property back. That forms a trust. And I would say that specific property back if I was also the grantor and the beneficiary. Now, I could specify that property to be gotten back, not to me, but to be given to a third party, which would be maybe a beneficiary that was also designated. So it could be another party there. So the example, an employer withholds a portion of each employee's pay with the understanding that the employer is obligated to deposit certain amounts in an employee pension fund. The employer probably has a debt for this amount rather than holding certain properties in trust, as long as the withholding did not involve identifying and setting aside particular dollars. Same thing as the other example. Identifying and setting aside particular dollars, an expectation would be that the employer is to make the deposit at the appropriate time for any funds available. Now the next one is compare. When a party is obligated to hold for the benefit of another specific funds received from a third party, the result usually be that the funds constitute property held in trust. And then the agreement here to pay half of funds received from certain ship sales as commission held to the trust pertaining to this case here. Kramer versus Worldwide Trading Company. So number one note, interest and payment denotes debts. If the transferee is obligated to pay interest or some agreed substitute therefor, this is virtually conclusive that the relationship is a debt. The fact that the interest or the principal is to be paid to a third party is not likely to matter. If, however, the transferee, that would be, say, the trustee, only promises to pay, promissory note, whatever interest or income the money earns when deposited in a savings account or invested, the relationship is more likely to be a trust. But did you express that? So the interest would be construed to be a debt. So take note that the interest of payments as an element to prove the debtor-creditor relationship, but that's only pertaining to if you first didn't express it to be the trust. Because if you express it to be the trust, then the interest is under trust, not under debtor-creditor. I go back to the Bank Officer's Handbook of Commercial Banking, 6th edition, by Schroeder. I go to section 19.02, I believe it is. Under C, special deposits, I'm going to jump down to the last sentence there in that section. It says, special deposits are often payable upon demand, sometimes upon terms, and occasionally they bear amounts of interest. So special deposits can bear interest. Now, whether it's bearing interest under special deposits under trust deposits, or whether it's bearing interest under debtor-creditor, so they're leaving out something that they're telling you. Just because there's interest on some kind of contract does not mean it's debtor-creditor. It could be interest on a trust deposit. So next is B, consequences of distinction between debt and trust. 1, insolvency. If transferee is merely indebted to transferor and transferee becomes insolvent, transferor would have the same status as any other creditor. If, however, the transferee is trustee of funds received from transferor, transferor could claim those funds or trace them to other identifiable assets and thus obtain priority over other creditors. And in fact, have an exclusive right to the trust property. And 2, profits. If a debt is involved, the profits realized on transferee's investment of the funds normally belong to transferee. The transferee merely has an obligation to repay the amounts owed to transferor, including any agreed interest. On the other hand, if the funds were held in trust, profits would belong to the beneficiaries and not to the trustee. Losses. If the relationship between the transferee and transferor is a debt, transferee owes the amount in question to transferor regardless of any losses sustained through the investment or theft. If the relationship is a trust, losses from investments or theft merely diminish the trust res, that is, the beneficiaries bear the loss. And the transferee is not personally liable as long as he conformed to the appropriate fiduciary standards of care, etc., in managing and caring of the property. If the transferee had been negligent in trustee, transferee could hold him liable by way of a surcharge, and if the loss resulted through no fault of transferee, the party who would bear the loss would depend on whether the relationship was one of debt or trust. Next section, 5, equitable charge, section 48. So an owner of property may devise it by will or transfer it inter vivos to another, subject to an obligation to a third person. In such a case, the third person may be held to take the property subject to an equitable charge or lien. Restatement the third 5, comment H. An equitable charge is like a trust in that equitable property rights are vested in the beneficiary, but it is merely an encumbrance or lien against the property, whereas the beneficiary's interest in trust property actually involves equitable ownership of the property. Example, transferor devises Blackacre to transferee, subject to transferee's paying my debts to friend. Transferee holds full legal title, subject to the equitable charge in favor of friend. So guide distinguishing these. Whether a transfer results in a trust or equitable charge ultimately depends on the transferor's intent. If the transferor intended to impose duties on the transferee to deal with the property for a third person's benefit, a trust is created. But if the transferor intended was only that the property stand as security for payment, a sum of money to a third person, an equitable charge is created. So if you don't understand what you're doing, if you don't know what your intent is, you can make it go either way by intending it, by understanding it. But if you don't, you're going to open it up free for courts to construe it. Number 1, the terminology. Phrases like subject to payment of or upon condition that she pay suggest an equitable charge rather than a trust, but are not conclusive because it depends upon the transferor's intent to impose the duties, and then it's a trust if there are duties imposed. Number 2, parole evidence or spoken evidence. Parole evidence concerning the relationship of the parties is admissible to help ascertain the transferor's intent. 3, other considerations. In attempting to classify the transaction, it is relevant to consider whether it appears that the transferor contemplated that property could be used by a transferee for her own benefit without any accounting, subject only to the obligation to pay the agreed payments. A trustee generally cannot use the property for her own benefit and is subject to an accounting. Example, transferor conveys Whiteacre to transferee, subject to transferees paying all monies needed for beneficiary's education. Absent evidence to the contrary, most courts would probably hold that the transferee intended only that the property stand as security for transferee's obligations to the beneficiary, and hence only an equitable charge is created. So there's a lot of construement going on here if you're in the dark and ignorant and you don't know what your intent was, although it was demonstrated, and they're going to construe it to be different than what you intended because you're in the dark. So compare. If the grant had been made upon condition that the transferee sell the property, invest the proceeds, and apply them in their income as indicated, it would probably be held to be a trust, because then it would appear that the transferor intended to impose upon the transferee a duty to deal with the property, and at least in part for beneficiary's benefit. Incidentally, unless there is found to be a matter of construction that any excess over what the provided for the beneficiary is retained for transferee's personal benefit as an additional beneficiary, the excess would be held upon a resulting trust for transferor's successor and interest. B, comparison of trust and equitable charge. Title. The beneficiary of a trust is an equitable owner if the property, although the legal title is in the trustee. The beneficiary of the equitable charge is not the owner, legal or equitable, having merely a lien on the property, which is otherwise owned by the transferee, and any surplus thus belongs to the transferee rather than being held upon a resulting trust. Subsequent transfers. If a holder of a title conveys to a bona fide purchaser, this can cut off the equitable charge, just as it can cut off the beneficiary's interest in the trust. Note, however, there is a deed to real estate as involved. The beneficiaries in either case can be protected by proper recording, which serves to subsequent purchasers on notice of the beneficiary's interest. Some liens on personal property may also be recorded under Article 9 of the UCC. And you might want to look up UCC 3-303B, and which is really where the accept for value comes in under debtor-creditor here, and the one who establishes the holder in due course status by doing acceptance for value on it is actually going to be the one who's going to be reversing that, and then that's going to cut everybody else off after you've done an acceptance on it. You might want to check into that further. 3, income. Income of the trust belongs either to the income beneficiary or to other beneficiaries, whether they need it or not, and the beneficiaries, including, if need be, the grantor as beneficiary of a resulting trust interest, are the equitable owners. However, the holder of the equitable charge has a lien on the property, including its income, but no rights to the income as such. Remedies. As a general rule, neither the trustee of the trust nor the guarantee of property grantee of the property subject to an equitable charge is personally liable for making the payments in question. The beneficiary of trust enforces his rights by suit in equity to compel the trustee to perform her duties, but so long as no misfeasance is involved, only the trust property is responsible. The holder of the equitable charge enforces his rights simply by foreclosing his lien or his charge against the property, unless the charge expressly or impliedly imposes personal liability on the grantee if she fails to perform. 5, fiduciary duties. There is a fiduciary relationship between trustee and beneficiary, but not between the holder of the equitable charge and the transferee of the property. This factor may be important in analyzing dealings between the parties. Example, whether one owed a duty to the other to disclose material facts concerning the value of the property. 6, conditional fee. A condition in a grant for the benefit of the grantor or a third party may at times suggest a trust relationship. For example, a conveyance from the father to son upon condition that the son support the brother for the rest of brother's life could conceivably be construed to 1, impose a trust, 2, create an equitable charge on the land, and 3, create a determinable fee or fee subject to a condition subsequent. A, consequences of distinction. Whether title is held to be a determinable fee or a fee subject to a condition subsequent, any failure or breach of condition subjects the estate to termination and entitles the transferor or his successors in interest to recover the property. A failure of trust duty, however, entitles the beneficiary to sue in equity to compel the trustees to perform his duties. Rule of construction. Generally, courts are reluctant to give word of condition literal effect where forfeitures on failure of condition would result. See property summary. Hence, unless the language makes clear that a condition was intended, a grant will usually be construed as creating a trust or equitable charge rather than a conditional fee. So this is particularly so where the condition for the benefit of someone other than a grantor, inasmuch as a breach of a condition would give one intended to benefit no legal or equitable remedy, the property simply reverts, whereas the beneficiary of a trust or equitable charge has equitable remedies. Now, other relationships. Various other fiduciary relationships may at times appear similar to trust. An example, guardianships, receiverships, and position of executors or administrators of estates, even corporate directors, partnerships, or limited liability companies. Restatement the third, 5 comments, E, D, and G. Each of these differs from a trust in some or all of the following respects: the nature and character of the title held by the fiduciary, duties and the powers of the fiduciary, and the remedies available for enforcement. Other bodies of law also deal with special uses of the trust device, such as a REIT, Real Estate Investment Trust, Voting Trust, Massachusetts Business Trust, Employees Benefits Trust, none of which are dealt with specifically in this summary. And there's a little graph there on page 14 there, the distinguishing characteristics of a trust and non-trust relationships. And you could look at that if you have the book. All right, so now the next section we want to jump to the next time we get into this next week will be in expressing the trust. See if I find what page that's going to be on. Okay, that's going to be on page 77, I believe, where we're going to pick up at next time. Yes, Chapter 3, Creation of Express Trust. So this is expressing the trust. And we also want to maybe see page 19, also expression of trust intent. But we'll pick up next week on page 77. And we'll get into 78, which is the methods of trust creations again, which are, without knowing what I just went over and what's coming up next week, you're totally lost. So, I'd like to welcome everybody to my show on Saturday that I have at 7 p.m. Eastern Time. The title of the show is Money, Banking, and Trust by Moving Titles and Commerce. And you can access that from the web if you tuned into the link therealpublicradio.net. Or you could ask questions. To call in for questions is 712 area code 432-8773, and the PIN access number is 179441#. And also, if you want to send me an email, my email address is movingtitles, one word, movingtitles@hushmail.com. So, Matt, why don't we open it up for some questions?
Okay, Christian. Folks, if you have a question for Christian tonight, go ahead and hit *8 on your phone. And as soon as
what I've been finding is really that I think everybody's more ahead in their own thinking, but really they're not. Because I've been asking a few people here and there about, just some basic stuff. Because and I found out that they couldn't come back to the very beginning and identify just the basic elements of the trust. And how you're forming a trust, or how are you going to be able to prove the trust? Because if you claim you have a trust, you're going to prove the trust. In order to prove a trust, you're going to have all 4 of the elements there, and you're going to have one or more of the methods of formation that the law will recognize. And if you don't come up with the evidence that the law will recognize to have a trust, then you do not have a trust. Now you're in big trouble again. So the question is, I've been finding out that most people do not know the simple basics on how to go back to the elements to prove the trust. So I went over an example with one fellow. He said he's got something coming in. It was a water bill for a water cooler, like in an office-style thing. And he was doing an except for value on that. And I told him, hey, you need to think trust. Get off of this debtor-creditor stuff except for value right now, because I don't think we're operating on the right wavelength. Because if everything is really trust, because we're not operating with any money, then why are we coming in with something dissimilar, say debtor-creditor relationship or UCC except for values, when it's trust? We need to be coming at trust with trust. And if you want to make yourself the 900-pound gorilla and have success, it's key that you understand the basics so that you can flip this thing back over onto them and pin them in 30 seconds because that's how they do it to you. So I found out that, all right, I started asking some basic questions. Or I asked him, okay, where was your trust supposedly formed? And he's talking about doing accept for value on the bill, and he signed the bill. No, I said, okay, where was your trust formed? Where is your nexus? Where is the whole thing coming about? Where did they get the ability to send you a bill? So they're not thinking. You got to go back to the beginning. Where did this all start? With your signature, with your first signing. And I asked the fellow, well, didn't you endorse something? Didn't you sign something? So people are not thinking that one of the methods of formation, which is endorsement, they're not putting it together that endorsement is a signature. When did you sign or first endorse something? Your first signature, say, upon the application of a mortgage, was the first thing that started the whole ball of wax. That's where the trust was formed. And his first application for this water cooler, where he put his signature on there, was the first place where the trust was formed. And then he said, well, he didn't sign anything. He just ordered. They sent it to him, so he didn't sign anything. Well, I said, okay, if you'd know trust basics, you would know that also B, delivery. Under 2B, delivery. Did you take delivery of the product? By taking delivery, you had one of the methods of formation, and you just formed a trust by delivery, by them delivering the product to you. So you can see that this fellow was totally confused because the poor guy didn't understand the basics. And I'm sure most of you that are in this trying to study it, I understand, but you're confused because you don't know the basics. So I would suggest that everybody's on this call and wants to pursue this, that you make sure you get Gilbert's Law Summaries. It's only $28. Get Gilbert Law Summaries on Trust by Edward C. Halbach Jr. and start reading it and start thinking about trust eyes. I mean, we've all studied this debtor-creditor stuff, UCC filings and things, and except for value and all that. But, hey, let's put all that behind us and let's look at this in a new perspective. We need a paradigm shift. And if you do a paradigm shift, you're going to come up with a revolutionary new technology that's on an equal part, at least with these people, because they're operating in trust. And I think you need to be operating in trust, too, if you're going to have any success at all. So, who's up first for a question? State your name, where you're from.
So far, nobody has volunteered to be our first Christian. Go ahead and hit start on your phone, folks. Star 8. There we go. Here's our first caller with a question. Go ahead. You've been unmuted.
That's a pretty good question. Next one. Those are the ones I like. Hello.
Hello.
Yes, can you hear me?
Yeah, this is Rhonda.
Hi, Rhonda.
Christian, I love it. That gorilla's gained 100 pounds in the last week.
That's right. It was 800 pounds. Okay.
Maybe could you ask me a couple questions to see so I can test my knowledge of how well I'm grasping this?
All right. Well, let's kind of speak in hypotheticals then. So, what was yours? Did your offer come in through the mail?
Yes.
Okay, so it wasn't a live presentation then.
No.
So I'm going to look at UCC 3-115. I'm going to be thinking all along 3-115. That's incomplete instruments. So if I don't have a signature on a document, say by grantor, by trustee, or by beneficiary, in other words, if I haven't given a qualified signature, I don't really have to worry about that because I can always come back and then say that it's an incomplete instrument. that it was my intent to some other words or numbers were to be added later on. So if your offer came in the mail, and I don't know, have you done anything on it now so far except for value or anything like that and all that?
No, I haven't.
Okay, so, really I'm coming back down to, I'm going to ask, where was the first nexus? Where did this all come about? I mean, how did they send you an offer?
Probably originated from a 1040 form.
Okay. So this one might come back even farther yet, because now we got to go back to the first signing of documents. Because
the Social Security.
Yeah. So there's where the whole thing started, because we want to go back to where the first signature was applied to create the whole mess for them to have the ability to send you a bill. Because he was focusing on that example that it was given. He was focused on the immediate bill that he had in his hand, or the one that he just accepted for value. But that wasn't the thing that brought it all into existence, because somewhere along the line he had to have done an acceptance on the original contract. And even the fact that he didn't sign anything, he still had accepted delivery, and that delivery was what formed the trust. So, my question is, where did that first signature come about?
Well, the SS5, I would say then.
Yeah, but did you sign that, or did your parents sign it?
The SS5?
Yes.
I signed it. I just got a new one here recently that I don't know if you would consider this to be a qualified signature, but I put by in the name.
Well, by is putting up some kind of question that you're operating in an authorized representative or an agency capacity or something, So there is a question in there. You could put like 3 dots and then sign your name, because, like 3 dots indicates that there's something missing and it's going to be added somewhere along the line. It's an incomplete.
Oh, that's cool.
I could put 3 dots before my name, or maybe I could put 3 dots after my name, because that would indicate something needs to be added in there, and that might slide by that nobody might say something.
So to go back to... Go ahead.
That kind of situation, it's going to bring in some tricky stuff, because now we're talking about the main subtrust, and I've been thinking lately that everything is already set up for us already in the strawman trust, and I'm thinking, why do we really want to terminate it? Because everything is in existence and operating fine, except we just don't know how to understand how to operate it. We don't know how to administer the trust. So I think it might be better maybe to claim that instead of try to terminate that.
To claim that beneficiary, the equitable side of the title, and send it back to the holder of the legal side of the res.
Yeah, I don't know if I'd want to merge the titles and collapse or terminate that trust. I might want to just do an enforcement on that to make the trustee, after I reestablish that I'm not the trustee. I'm going to then go into court of equity and force the trustee to actually do the disbursement of the funds, or the duty that was set up. But first, I would still have to claim that there was a trust and prove that there was a trust. In order to be able to prove the trust, I'm going to have the facts established.
Okay,
and I'm going to have to
if I'm getting if I'm getting a bill, if I'm getting a presentment through the mail that is looking like it's based on the 1040, but which we know that goes all the way back to the SS5, but I don't want to terminate the straw man trust, because I can use it if I know how to use it.
Right.
Okay, but with the 1040 situation coming from the IRS, that offer, is that half of a title? Is that a lien?
Well, what they're trying to do is lien you. Section 120, page 127 in the book. Page 127 in Gilbert's. Under Section A, alienability of beneficiary's interest. On page 127. That's Section 441. So it says in Section 1 there, number 1 on Section 441, right to transfer. A beneficial interest in a trust are freely alienable. So in other words, anybody can put a lien against it. So beneficiary's interest in a trust are freely alienable by the beneficiary unless there is a valid provision to the contrary in the trust instrument. Now that right there could be pretty powerful. Unless there is a valid provision to the contrary in the trust instrument. In other words, if there was, then you couldn't even put a lien against me. So thus a beneficiary can assign, pledge, or encumber her interest or even transfer it to another. And also, if the interest is not conditioned on the beneficiary's survival, it will pass by will or by intestate succession. And A, the rationale, the beneficiaries are equitable owners of the trust estate and their interests are property, and each therefore has power to transfer and convey her interest in the trust to the same extent that she would transfer her own property. Now the big one, under B, Section 442, this is where I was coming in for, transferee's rights. So the beneficiary can assign only such interest in the trust as she has. The transfer is not a transfer of the trust res itself, but only of the equitable interest therein. Whatever conditions or limitations, now that would be the lien, whatever conditions or limitations attached to the beneficiary's interest prior to the assignment apply against the assignee or the one that you're going to transfer the title to. So the assignee is now going to be flipped the hot potato. So this is, I would liken this to under debtor-creditor where you do an acceptance and a return. But this is not acceptance or return, this is trust, but yet it achieves the same effect.
So it's a transfer in the equitable title.
Yeah, so you're really going to have to pay attention to the two types of title, the legal title and the beneficial title, and who has which title.
Well, they have legal title, so it might be better to think in terms instead of thinking of something coming in.
Well, they're construing you to be the trustee. So the trustee
right.
supposedly is holding the legal title, and they're construing themselves to be the beneficiaries, or the agents for the beneficiaries, let's put it that way. They're collecting for the United States.
Okay. And so it might be better to kind of think in terms of they're sending me a trust instrument instead of a presentment.
They're sending you a bill because they've misconstrued this whole thing because you didn't know it was a trust and you didn't know that you were the beneficiary instead of the trustee. And if you would have made yourself out of court the trustee and run the affairs correctly, then you would never have been in this whole mess to begin with because you would have made the payment. Because you had access to all the funds anyway.
Okay, so they're construing me to be the trustee because I didn't express anything different.
Mm-hmm.
And they've sent me this instrument to pay.
Right.
So I want to claim it and reassign it back to them.
And that might be one way, but I don't know if I'd want to reassign it back to them because I might want to come in and prove the trust that I'm the grantor and the beneficiary. Once I prove that I'm the beneficiary, then I'm the one who can make the claim that the trustee has not done his duty. So if I'm not the trustee and I'm the beneficiary, then I would have to identify who the trustee is, and I'm going to identify them because I'm grantor and beneficiary and I'm going to identify them to be the trustee. So now they're the trustees. We've straightened all this mess out. Now the trustee is the one that's liable for all the bills and payments on the thing. He's taking care of the whole situation. If he screwed up, then it's his fault, not my fault. So that bill should actually go to the trustee.
The trustee being the one who sent it to me, or the trustee of the bankruptcy?
Yeah, because what I've done is I've effectively switched it back to them, because now I've identified them as, because they're thinking I'm the trustee, but I'm really the beneficiary, and now I've identified that I'm the beneficiary and appointed them, corrected the whole mess, they're trustee. You guys are trustee on this whole situation.
So
now, why are you sending me a bill?
That would be with a notice of interest and a statement of interest?
Yeah, to prove the trust.
And would I do all that, the NOI, the SOI, and sending the instrument back all at one time, or do the NOI, SOI, maybe send them together to re-notify them that, hey, you made a mistake, and then send them the instrument, claim the instrument, now that I've set up my beneficial interest in it, and send it back to them? Yeah,
I would claim the instrument and then do a UCC3 assignment back to them. That way I know that they've got the liability back on them again, instead of them doing it to me.
Would I do that? Would I do all that at the same time as I do the NOI and the SOI?
Yes, I would send the NOI and the SOI and the transfer, the whole thing, just send it to them all at once and tell them, this has been construed wrong. I'm straightening the whole mess out.
Okay.
Would you do it via due presentment through a notary?
Yeah, I'm going to have to make sure that, that we're creating a record of everything that we do. And the only way I'm going to do it is with a notary, so that I got the notary certifying everything that's been done.
Otherwise,
the whole thing is, the moving titles platform is just to create the evidence that I need. I need the two witnesses on everything to prove anything that I've done. And I want to take this like one step at a time, and it's like a string of dominoes. I don't want to leave one domino out of place, because when they all go, then there's a hang-up.
Okay, well, thank you, Christian. I'm going to get off here and let somebody else take a crack at you.
Well, kind of like when we're on the subject here, close to this section here on 442, this is probably the biggest bingo in the whole book. I might as well go into it because it's only a few pages away. It's only on page 131. And that is section 459. That's section B here, restraints on alienation or alienation, spendthrift, and related trusts. So in general, where it is generally recognized that beneficiaries are equitable owners of the trust, res, and that their interests are transferable, most states allow the beneficiary's interest to be conditioned or limited to prevent or impair transferability. So now it's talking about spendthrift trust in 460. A spendthrift trust is one in which by statute, or more often by virtue of the terms of the trust. The terms of the trust, that'd be the trust indenture. The terms of the trust, the beneficiary is unable voluntarily or involuntarily to transfer his interest in the trust. In other words, he cannot sell or give away his right to future income or capital, and his creditors are unable to collect or attach such rights. This type of trust is usually created to provide an interest for the beneficiary that will be secure against his own improvidence. Now, I'm going to read this again and forget about spendthrift trusts. So a spendthrift trust is one in which by statute, or more often by virtue of the terms of the trusts, and I'm going to say the terms of the trust is the Declaration of Independence, the beneficiary is unable, voluntarily or involuntarily, to transfer his interest in the trust. In other words, he cannot sell or give away his right or future income or capital. And his creditors are unable to collect or attach such rights. This type of trust, the Declaration of Independence, is usually created to provide an interest for the beneficiary that will be to secure against his own improvidence. Now, we're in a section here talking about alienability, but in the Declaration of Independence, it's talking about unalienable rights. So God set up this trust for us so that we would be secure against our own improvidence, because the rights, we could never give them away because they were gifted to us, held in trust, and they are not subject to any collection or attachment rights, period. Now, I don't know, it could be so simple as to claim the Declaration of Independence and bring that information in on the private side in chambers and put the public motion in on the public side of a hearing and go into that hearing and have the judge instructed, and along with probably a protective order for his eyes only, to look at the evidence and return the order of the court to me. Because the real rights of the substantive man are relying in the trust side, the equity side of the court, and that's where my Declaration of Independence is, and the real rights, where my unalienable rights are that were given to me by God. I don't think they want to argue about the Declaration of Independence in this country, or else they're going to have a revolution on their hands. I don't think it could be much more simpler than that. Now, that one's probably the biggest one in the whole book here. Just like Dorothy in The Wizard of Oz, as soon as she came into Oz, the Good Witch granted her a gift of the silver slippers, which was the power to get back home. And she wore those all through the movie, not knowing that all she had to do was click her heels together 3 times, and those 3 clicks were right, title, and interest, which is trust. So she was trusted with the gift of the shoes right from the start, because that's when a trust formed in that movie. And she had the power all along. So do we. We just never knew or understood it. So, next question.
If you have a question, folks, go ahead and hit star 8 on your phone. And as soon as I see you come up here, I'll unmute you and you can ask a question. Okay, we just had 2 pop up, Christian. First one is in California. Go ahead, you've been unmuted.
Yes, Christian. Hello.
Yes, go ahead.
Yes, good afternoon. Yeah, I got to take off my hat to that lady that challenged her own wisdom, her own knowledge. She was brave about it, yeah. Anyway, what about the expressing the trust when it comes to an OID? Is that something similar, or am I stepping out of the ring?
As to an OID,
yes,
the OID's got to do with interest, and that's part of the trust.
Right.
So I don't understand a little more about. You have to fill me in with some of the details there.
Yeah, let's say like if you want to express the trust on when you purchase a home and you want to OID that whole transaction and get your money back.
Okay, now that's kind of out of the realm of trust, because that more falls under the OID process that we've been using in the past. Falls under the debtor-creditor, really, I think.
Okay, so we're going to get away from that, right?
Well, I don't think we're going to get away from the OID, but we're going to get away from the past way we've used it.
Okay, right. Okay.
So I went over on a Saturday show about 2 weeks ago. I went over the W8 BEN, and last week I went over the W8 IMY. And I talked about the substitute forms there. And those substitute forms and the instructions, both those forms are talking about interest and interest pertaining to OID. So I think the correct administration of the trust is going to really involve IRS forms in particular, and maybe other forms also, maybe GSA, in the administration of the trust. but the way we're going to be using these forms are probably going to be totally different than the way we used them in the past. And also, I would get publication 515, and I would do some research on the terminology that they use in there under interest. Publication 515. See where we got it at here. Publication 515 on page 14 talks about income subject to NRA withholding. And NRA stands for non-resident alien withholding. And it says this section explains how to determine if payment is subject to NRA withholding. In other words, it's taxable. And it's taxable because it's effectively connected with a U.S. trade or business or ECI. And anything that's ECI is, if it's connected to a trade or business in the United States, is taxable. So it says amounts not subject to NRA withholding. The following amounts are not subject to NRA withholding. And there's 7 bullets here, and I'm going to jump to the second bullet, which is bank deposit interest. Then is not effectively connected with the conduct of a U.S. trade or business. See interest later on page 18. And then the next to last bullet talks about original issue discount paid on the sale of an obligation other than a redemption. The original issue discount later. Now the next section is source of income. Now they left out a couple things in there because really the whole section is not only talking about income in the first paragraph, but it's also talking about payment, and it's also in the second paragraph talking about interest. In fact, there's 2 paragraphs on interest. So we're really talking about source of income, source of payment, source of interest. Income, payment, and interest, the source of it. So generally income is from U.S. sources if it is paid by domestic corporations, U.S. citizens, or resident aliens. Notice it didn't say non-resident aliens. And the payments, it says, is treated as being from the source within the United States if the source of the payment cannot be determined at the time of the payment. Blah, blah, blah. And then generally interest now. Interest on the obligation of a foreign corporation or a foreign partnership is foreign source income. And interest paid by such entity is treated as from U.S. source only if the interest is paid by U.S. trade or business conducted by the entity or is allocable to income that is treated as effectively connected with the conduct of a U.S. trade or business. Now going to page 18, on the right-hand column, the top, interest on deposits, which is income code 29 on 1042S. Foreign persons are not subject to withholding on interest. Foreign persons are not subject to withholding on interest that is not connected with a U.S. trade or business if it is from, and there's 3 bullets. First bullet is deposits with persons carrying on banking business. Now, aren't you a bank? I mean, I could go to the Banker's Handbook again under that section, that 19.02 section. I keep on going to special deposits, and then below that is certificates of deposit. And then the next section is opening an account. And it says in opening an account, opening an account in a bank involves only a simple contract in which the depositor lends money to the bank. The depositor lends money to the bank in return for an agreement by the bank to pay back the amount either with or without interest. With or without interest. Interest. That's interesting. Also, on the special deposits, Occasionally they bear amounts of interest. Also, now down the next section, certificates of deposits. And it says, when negotiable, the bank simply contracts to return the amount to the, non-negotiable. When non-negotiable, the bank simply contracts to return the amount to the depositor plus any contracted for interest. Interest. Very interesting. Again, interest on deposits, back to the 515 publication, that is not subject to withholding on interest. Deposits with persons carrying on the banking business. If you're making a deposit into the bank, I'm asking you, who's the bank? It's not them.
You are.
Yep, you are. So shouldn't we be issuing certificates of deposit? Deposits, next bullet is deposits or withdrawable accounts with institutions chartered under the federal or state laws or similar associations. Now that could be brokers, and on the 1040 W8 Ben it talked about, and on plate 7 there, talked about broker transactions and broker exchanges. These could be similar associations. And the last bullet, amounts left with an insurance company under an agreement to pay interest on them. Now think about interest being on special deposits or trust deposits by non-resident aliens with a W8 Ben and a W8 IMY using the substitute forms for those. Not the original ones that they give you that'll get you trapped up in a minefield in about 3 seconds. Deposits include certificates of deposits, which I just read in the banker's book, open account time deposits, and other deposit arrangements. Now, weren't they talking about contracts with the banks or contracts with brokers? Other deposit arrangements, the trust or special deposits, private non-negotiable transactions. Our problem is we're commingling funds, ladies and gentlemen. 9-336 talks about commingling funds in UCC. Banker's Handbook talks about commingling funds. Gilbert's Law and Trust talks about commingling funds, keeping things segregated for a special deposit in order for it to be a trust deposit that is not subject to interest and can be taxed upon or withheld.
That's 336, right?
9-336, yes.
Yes. Yeah, let me ask you something else real quick so I can give somebody else an opportunity to ask them a question. Now, going back to foreclosures, I get this question a lot. Does it really matter? I'm not talking about, I'm just asking your opinion. No, I'm not talking about trust. Does it really matter whether a home was assigned or it claims to be the beneficiary MERS? Does it really matter in the trouble they are versus some other bank or some other corporation? The fact that MERS is in your contract, does it really matter? I mean, are you in a better position of keeping your home? That's my question.
Well, I would say if MERS is specifically mentioned in your security interest agreement there, that effectively MERS has been knocked out of the box to do any kind of assignments. And if they come in at the summary judgment with the affidavits to prove that there was assignment made, then it comes back to MERS, and MERS can't assign anything.
Right. Yeah. So basically, they are, whoever has MERS on their contract, they are in a better position, obviously, right?
I would say if MERS is mentioned in there, they are in a better position.
Yes, yes. Right. Hey, thanks, buddy. Let me give you somebody else the opportunity to ask. Thanks again.
All right, our next caller is Central Coastal California. Go ahead, you've been unmuted.
Yes, I need some contact information on your course and your materials, Christian. I've listened to some of the broadcasts, in particular the early November one where you came out with Re-Expressing the Trust. Is there a way we can see the documents as a starting point? Do we understand them?
Well, the documents are going to be in this Gilbert Law Trust.
Okay. Sometimes it shorten the learning curve. For example, if you have some suggestions on the Social
If you haven't
Security
read the book,
dropped.
you ain't shorting anything but your noose.
Okay. And that's
I don't mean to
Gilbert.
be facetious, but you're your own worst enemy.
Oh, yes. I think it was Pogo that said, I've seen the enemy in his eye.
Yes. A little bit of knowledge is dangerous, That's
Okay.
This trust stuff that we need the basics.
You were going
first.
to have classes, you said?
Yes, workshops. Yes, I've got everything, working out the last minute details on it.
Okay.
They're going to start
Have you had one this last month, or are you still waiting to give it?
No, I'll be after the first year. They'll be scheduled in January.
Okay.
If you just have one of the audio downloads.
I
November
have in particular the November 7th for the major download. I have reference for some of the others too.
I have an email I sent out to people that has a group of links on there for a bunch of past shows. There's probably a dozen of them or more.
Okay.
And also a little study guide with the Gilberts to look at certain sections in the book. If you send them an email at movingtitles@hushmail.com and request the audio downlinks, I'll send them to you.
Okay. My specific case is in a few weeks they want me to be the trustee and put me in prison for 4 years on a bogus charge, and I've got to re-express it or do something pretty quick.
Right.
I'm hoping that would have a desired effect.
It's if you know what I know, have success. But do you know what I know? That's the problem. And I just can't impart to you what I know in a download or a couple audios.
I got to stress that, but I'm a motivated learner.
Okay, well, the faster you pick it up, the quicker we get there. So,
Okay.
The best information is those downloads on the NTT that we talked about on the past shows. If you just have the one, send me a request by email, and I'll send you the links to the rest of them.
Okay. And on
Gilbert's Law Summaries, Trust.
And on the talk show, is there a download code?
No, you just go to, let's see, what is the PIN number is 41875, and that'll get you into that where you can download them.
I put that in there on TalkShoe, and they said, that doesn't come up with anything.
Matt, do you think you might be doing something wrong or something?
The caller that's talking to you, you're not connected into TalkShoe Online, are you? Because I could post it right on the
No, not at the moment. I'm on landline. However, I had TalkShoe up as we're talking.
Are you connected to the Free Americans Yahoo group?
No.
Okay, because every week I send out the announcement for tonight's call, and it's got a link right to the page where all of our when you click on that link, it'll bring you right to 41875 where all of our audio downloads are.
Okay, that's Free American.
The Free Americans, plural. It's the web page.
Free American.
Yep, the web page is groups, G-R-O-U-P-S, groups.yahoo.com / the word group, G-R-O-U-P, / the Free Americans, plural. If you go to that page, become a member, go to the posts. If you look at the posts every week, you'll see the email that was sent out or the announcement that was sent out for tonight's calls. And in that post, there's a link right out to TalkShoe to 41875. Click on that. It'll bring up our TalkShoe page, and it'll show you all the weeks. Christian started about 6-8 weeks ago, and we're on week 43 now. So it'll be the last 6 to 8 weeks of our calls.
So, in other words, your seminar session basically is going over the book and the material.
Right. Yes.
Okay, I've been in trust for about the last 12 years, and but I've learned some, but I'm sure I'm nowhere near up to speed where you're at.
But you're using trust in a totally different aspect.
Okay. Well, I'll get hopping on it then. Now, when we express the trust, does that explain where we send that expression?
Whatever problem that you have trying to solve, because normally you're being in court as to be the trustee, and I'm going to come into court and construe, recorrect that misconstruement to be I'm the grantor and beneficiary.
Okay. So it's not just a general.
I have two options. The beneficiary has been established as being me, and I'm straightening out that misconstruement, me being the trustee. Now I'm the one who can make the claim to the trustee that they didn't do their job and they're in breach of duty. And if you were on some of the past shows, that is a powerful position, because now the burden of proof shifts to the liability on the trustee, and he can't prove himself to be innocent because he's presumed to be guilty right off the bat once I make a prima facie case as beneficiary. If I say prima facially that he didn't pay me, the court is going to assume that he is guilty, period. And he has to prove himself innocent, and he can't if he hasn't made a payment. That's how they get. So what we do is you can just
judge be in that position. Do we, for example, fill out a Form 56 on the judge? No. Everything under debtor creditor that we've learned under except for value and all that stuff is different. Just forget that stuff. The trust is totally different. Okay, so the Form 56 would not name the judge as a trustee? No. Oh, somebody has to be a trustee. Not under trust. Okay. Good. Yeah, I'll get on it. The question that you're asking me proves to me that you don't know what you're, not to be insultive or anything like that. I want to learn. Yes, because it tells me right off the bat that you don't understand about the four methods of formation of the trust. Because one of the formations of the four methods of formation is declaration. Now that's words or conduct. 2 is transfer. 3 is appointment. And 4 is contract. And number 2, transfer, also breaks down into sub A through D. And A is endorsement, and B is delivery, and C is assignment, and that's on a UCC 3. And D is by operation of law. So notice given generally is on the UCC. Yeah, if I'm going to do an assignment, that's where the assignment on UCC 3 comes in to whoever assigned the appointment to the trustee. Okay. And by delivery, he's going to be liable as long as I can prove the delivery, prove the assignment on a UCC 3, have 2 records to prove that was done. Then that classifies as one of the methods of formation. As long as I've got the 4 elements of a trust, and that's intent, purpose, parties, and specific trust res, then we got a trust. Okay. And as long as I can prove that by creating the record or the evidence, a record is evidence, material fact, then I've got a trust. The law must recognize that I have a trust. Okay. And once I've got the trust, I've straightened around who the beneficiary is on this and who the trustee is. Now I'm in the position of the beneficiary to make the claim. And I can make the claim that the trustee didn't do his duty. He's in breach of fiduciary duty. And if he doesn't have the proof that he dispersed the funds, then the court has to deem him guilty because he has no evidence otherwise to the contrary. He's in violation of the trust. If we're grantor and beneficiary, then who would we presume the trustee is if it's unspecified? Or the point is we have to specify?
Whoever the trustee is the intent and purpose of the grantor. And who's the grantor?
Okay.
You are.
Yes.
So if you don't know who the trustee is, who does? The court's going to construe it, and they're going to construe it to you to be the trustee. You see what my point is?
A grantor at age 15, Okay. Which carried over once you turn 18.
Well, I don't care whether I'm 15 or 18. As long as I don't know, that's the problem.
Okay. I'm getting there.
What I need to do is get the knowledge and the understanding of who I really am. And knowing who you are is not knowing that you're creditor or that you have standing. Knowing who you are is that you're grantor. Remedy is not in the debtor-creditor relationship as secured party creditor. Remedy is in trust, and it's in commerce through equity and trust. And whoever claims the trust must prove the trust. But if you don't know that you're in a trust, how can you make a claim that there is a trust? And then they construe it that you're the trustee, and they put you under debtor-creditor as a trustee, and you didn't make the payment. You're guilty. Once they make a prima facie case against you, you're presumed to be guilty unless you can prove that you made a payment. And if you didn't make a payment, you can't prove yourself innocent.
Okay.
But you didn't know you had to make a payment. That's the problem. You didn't know that you were actually the beneficiary.
Okay.
So this is a big hodgepodge of jumbled yarn that all has to be unwound and recorrected, and you're the only one who can correct it, and you got to know what you're doing.
Okay. Sure would be nice if I had a step sheet to click off. I guess I'm looking for a shortcut.
Well, what happens if the judge says there's no trust here when you brought all your proof in?
First of all, you don't even bring it into the court. Once you do that, don't you give it up, Christian?
Yeah, if I brought it in on the public side, I would waive it, yeah.
Right. You want to give it in to the judge in his chambers privately for his eyes only.
In camera. Okay.
Correct. As soon as you start arguing with the judge that you have a trust there, you just lost it.
Yeah, if you're on a public side, yep.
Yeah, exactly.
Okay.
So hang in there,
Oh, yes. I'm a motivated learner. Good. So the next step is I'll get a hold of the group on the Free American group, and that'll give me some more download information.
Yes, right.
Also do what Christian said. Go out to Amazon and get the book, Gilbert Law Summaries on Trust. It's less than $30, and with Amazon, it's free shipping.
And send me an email for the links that I've got.
Excellent. Okay. I love what you're doing. This is, in fact, I've passed this on. The broadcast I did have, I passed it on to many people because, hey, this is a key piece. This is what we've been working for decades over.
So I believe we've been totally going in the wrong direction.
I totally agree with you. We ran the common law court in Las Vegas for several years, and about a year and a half or so ago, 2 years ago, I shut it down because we didn't have enough answers. We had a lot of good teaching, but it was not helping. People were still going out and getting in trouble.
Well, here's what I find out. It doesn't make any difference what method anybody does. Usually about 10% or less all have some kind of success. What's that tell you?
Yeah, it's less than refined.
Yeah, but the point is, it doesn't make any difference which method you use. Whatever you use, it's like they're letting a certain portion through to make it look like, hey, to keep you on the track. Because you're not pursuing the right track.
Absolutely.
And the right track is trust.
Well, when I heard your broadcast the November 7th, all of a sudden a light dawned and stuff I really sort of already knew, but it didn't put re-expressing a trust. We kind of presumed that they were, the trusts were non-changeable, but that opens up everything.
Right.
What a powerful concept. I appreciate it. Thank you, Christian.
Okay, appreciate it.
We have 4 more callers, so we'll start knocking through them. First one's Blackwater Fraud. Go ahead, you've been unmuted.
Hello, guys. How are you?
Good.
Yeah, I wanted to. The one question I wanted to ask was, do you, Christian, or someone else that you may know, have any real practical experience with using this information and/or technology to any success? I mean, I know that it makes sense, and I'm still learning. I'm still pretty green. I just ordered the book. I haven't gotten it yet, and I've been reading the PDF version that floated around. But I'm just kind of curious as to, is there anyone out there who's actually put this to use and had success?
Well, we've done some trials on this in 2 different cases, and the one case that got the mortgage foreclosure was set for sale, and the sale got like 2 hours before the house got pulled off the sale block. In another case, we did the same thing, except we came in this time with the SOIs to support the NOI, and that case got closed down.
Okay. And, well, I had a couple other questions, but I think I know I forgot one of them. But one of them had something to do with the Department of the Treasury, and it seems like in some other information somewhere I found that the Secretary of the Treasury is really supposed to be operating as the trustee of the bankruptcy. So in relationship to the Internal Revenue Service, would we not be at some point wanting to express and or prove that the Secretary of Treasury is the trustee or should be acting as the trustee?
Well, under the old methods that we've been using, yes, the Secretary of Treasury was acting as the U.S. trustee under the bankruptcy. But I'm going to be doing nothing but shattering old foundations, because I'm going to say that everything we've done in the past has totally been wrong, conceptually wrong. The trustee U.S. bankruptcy is on the public side. That's under public debt. And here we are, we're commingling funds. We're trying to make the private side jive with the public side, and we're commingling. And we're getting into all these problems because we're commingling, because we're not treating it as trust, as being segregated. And that's what's causing all the problems.
Oh, okay, gotcha. All right, it's making more sense. Well, I think I had another question, but I can't remember what it is now, so I will defer to someone else. Thanks.
All right, next one is South Texas. Go ahead, you've been unmuted.
Let me make a comment on what he said first. If you look at the face of a Federal Reserve note, you're going to find that there are 2 seals on that bill, and those 2 seals underneath that is 2 signatures. You have 2 signatures under a seal. One of them is Paulson or, say, Geithner or whoever the Secretary of Treasury is, and he is on the right side, and coincidentally, the right side is just like if you drew a line down the center of that bill, the right side is on the liability side in this case, which is exactly opposite the way a normal ledger keeping is. The left side is the asset side, and that's where the black seal is. And when you're running in the black in a business, you're in the money, honey. So the black side, on the left side, is where the assets are, and the one who signs under that seal is Ana Escobedo Cabral. Timothy Geithner is the Secretary of Treasury. Ana Escobedo Cabral is the Treasurer of the U.S. The right side under Geithner is public debt, where the liabilities are, and the left side is the private side, where the real man is. Now, another thing, every portrait on every one of the Federal Reserve notes, they always say they're dead presidents. They are not dead presidents. I will tell you what they all are. They are all dead postmaster generals. Postmaster generals of what? The post office. The post office was the original bank before 1776 Declaration of Independence. It was in existence before the United States, before the United States of America. It was the first bank. It is also the UPU, and it's where all the assets are held in trust. And here we are coming through on the wrong side. We're coming through the Geithner side on the public side under public debt, and we need to be coming on the other side through Ana Escobedo Cabral. I'm shattering all kinds of foundations on misconceptions that are wrong. We've been doing it all wrong in the past. Your trust is held on the left side where the assets are, like looking into a mirror, which is really on the right side if you're looking at it the right way. Normally a ledger sheet, the assets are on the right and liabilities are on the left. But you're looking at the bill, you're looking at it through a mirror. The assets are on the left side, on the black seal. The right side is the green seal where the liability is. And by coincidence, the bank, or the U.S. Treasury, which is my bank, 1500 Pennsylvania Avenue, both Escobedo Cabral and Geithner are on the same floor, just offices down from one another. And Escobedo Cabral is also in charge of the mint out in San Francisco, where the gold is made. Everything has been construed wrong, and we've been following a path because we've had a few successes here and there, and we've been going down the wrong path. So, next question.
How you doing, Christian? This is Albert from Texas.
Hey, Albert, go ahead.
My question, by the way, I like what you said about the post office. I've found the same information. And
I had a bank account at the post office when I was a kid. I had a savings account. The post office is a bank.
Well, it's not even. It doesn't even belong to the people. It was created by King George II.
Yeah, well, I think in 1972, I forget what the USPS came into existence, right around in there. But all the property switched from the United Postal to the United States Postal Service.
Right.
But the effect was that there is nobody in the post office anymore running the post office. There's about 5 heads to that, and they're all in D.C. But they're not doing anything because it's all owned by the United States Postal Service, which is a different entity. But that doesn't mean it doesn't exist today. It's still there.
My question is, Christian, I remember maybe 2 months ago you were bringing out some rights. I came in late on your call, and you brought out that the trustee has no rights. So I'm wondering what rights the beneficiary may have.
Well, Black's Law says under trust definition, it says that some courts and legal writers have defined a trust as a certain kind of right that the beneficiary has against the trustee, or a certain kind of interest that the beneficiary has against the trustee, or a certain kind of interest that the beneficiary has in the trust property. And the trust property is represented by title. So there you have right, title, and interest. Right, title, and interest is talking about trust. And the beneficiary has a right to all that.
Okay,
so the beneficiary has against the trustee. And the beneficiary has certain kind of rights that the beneficiary has in the trust property, which is held by the trustee. So the beneficiary has all the rights against the trustee.
That's an angle that I'm looking at, and brought out that information.
Go ahead.
He has an equitable claim in equity,
to compel the trustee to do his breach of fiduciary duty if he didn't do it. And he also has a claim at law on the at law side of the case, or the court, I mean, to bring a claim against him. And then you also have commercial remedies also if you want to go back under debt or creditor.
Does a beneficiary have the right to be a grantor?
Well, if the grantor's intent was to be beneficiary, yes, he can be.
Okay. I guess I'll save the rest for Saturday. Thank you, Kristen.
Okay. Saving the best for last, huh?
Oh, yeah. I'm going to develop that one so that way I say it right. But I think, Kristen, that what I'm trying to do, as well as a few others, is I'm looking at it through the beneficiary angle, and what you just stated from of the rights of the beneficiary, it just confirms what I was thinking. And
right out of Black's Law, 8th edition.
Yeah, that's a good one. I barely found the 5th. When a beneficiary makes a claim stating that he is not receiving the benefits according to the indenture, that is the angle I'm looking at. What do you think?
You should look up in Gilbert's there, beneficiaries' rights and enforcement.
Okay. I just finished downloading that thing. It took hours, but I'm going to be looking at it just like you've been telling us. It's a big, huge book, I'm sure.
Well, it's 400 and some pages long, but trouble is it's wide-spaced print. It's a lot of pictures and diagrams. It's easy to read, and it's if you condense it down to a regular book form, it's probably half that.
Okay. Well, I'm definitely going to be studying because I've been looking at Scott's and I've been looking at Bogert.
Right.
And as well.
Get the UTC also, Uniform Trust Code.
Yeah, I got that one.
And get the one that's the Hague Convention. I forget what that one's called, but let's see. That one's called the Convention on the Law Applicable to Trust and on Their Recognition.
Okay.
Only about 10 pages.
I think I saw that file, too. I didn't think it was anything much.
Well, geez, on page, on Article 6, there in let's see, yeah, Chapter 2, Article 6, in there, it says that the trust shall be governed by the law chosen by the settler. There's some pretty good stuff in there.
You know, another question I think I asked you before, and
compare that to 9-702 in the savings clause under UCC.
That's the question. The UCC. You know,
all right.
You brought out the 2 signatures, and what I was wondering is, does a beneficiary or a grantor need to do a UCC 1?
No, I'm only using a UCC 1 or a 3 as a means to create a record or evidence.
I see.
And if you can create a public record some other way, you don't have to use a UCC 1 or a 3. I'm just using it as a notice for a record.
The reason I ask that is because I've heard the arguments of, the UCC is copyrighted, you're using their stuff, and blah, blah, blah.
But I'm not using it for proving any kind of UCC stuff. I'm using it to confirm, make a record of what was done, an act, a deed.
I see.
And also there's a block on there to clear to the right, I think it was the last one, it says non-UCC filing.
Yeah, you're right. It does say that. So in essence, we don't have to...
Non-negotiable.
Right. We don't have to follow UCC 1 like we were learning years ago. We don't need that. We just use the UCC as a means of notice and evidence. That's it. Yes,
1-202 in UCC, notice.
Now, using their forms will not inconvene anything, right?
No, because just like I read under Chapter 2, Article 6 there, in the Hague Convention, the law of the, how's it stated again?
Right, that as long as we're not using the forms for UCC procedures, we shouldn't. I'm thinking that's what you mean. We wouldn't be imposing on their copyright.
I'm not using the number, UCC number. I'm using the intent or the content of the UCC or the meaning.
Okay, so if we did our own page with the ideology that is on, like the UCC3, and we just worded it the way, we would sign the form, would that suffice?
I don't know if they take it. It would be maybe a non-standard form. Okay,
it was just a question. I was just looking at it that way. I just didn't want to give
that UCC filing and made it non-negotiable. It's not a UCC filing.
I see. Okay, well, thank you, Christian. See you next time.
Albert.
I'll be listening.
All right, Christian, here's our last caller. Northeast California, go ahead, you've been unmuted.
Hey, Christian, you got me?
Yes, I can hear you. Who's this?
Hey, this is Jim out in Northern California. I got your email the other day, Follow the White Rabbit. Thank you much. I appreciate it. I spoke to you last week. I told you that I had done a filing with the county recorder's office where I filed a statutory notice of preservation of interest, and I promised you I'd follow up with that information first of all. My house was up for trustee sale, so I filed that notice with the recorder's office, which, again, I was very surprised I got it filed. But I did get it filed, and my interest was a sweat equity interest that actually exceeded the amount of the value of the note. What happened was it went to trustee sale Monday here in California. We served the auctioneer with that notice of preservation of interest. It stopped it immediately. They wanted me to go fax this document back to the trustee, and of course I told them that wasn't really my job, but the trustee had already been noticed. We had sent that to the trustee already. So at the very end of the entire proceeding for the non-judicial foreclosure, they went ahead and they foreclosed on the property. However, we just spoke to the bank's agent today, and they're claiming, not the bank, but the beneficiary's agent today, and they're claiming that they have no idea what we're talking about. Of course, this was filed for record. So we're going to pursue it, and I'll continue to let you know what happened, but they've got a non-judicial foreclosure on the record. They did sell it at auction, but we're going to find out if we've got some equitable rights to this thing. So just wanted to let you know that did go through. And my question, just a quick two-parter. First of all, when you talk about getting a judge into chambers with your presentments for re-expression of trust or whatever it is that you're going for, specifically, do you have a method for getting a judge's chambers filing?
Yeah, you have. You're going to put in a public side motion that orders the court to do an in-chambers hearing, a notice of hearing. But then you have to have a reason for a hearing, and you're going to have a CCI information, secret protective information, that needs to be protected in order for you to have this special hearing. Which also brings in, protective orders under discovery. So you got trade secret information, which is the private substantial rights of the man, which is trust, really. CCI is trust. So you got to have a reason or a show cause reason why you got to have a hearing in chambers, and so you got to prove that you got CCI information or trade secret information.
And so in that proof, that's going to be in your discovery or within your evidentiary documents. You're basically going to show your documents in that, and that would be, of course, private. In a sealed envelope, I believe?
Well, they have to be sent in by a private letterogatory into chambers on the private side. Do not go through the clerk of the court.
No, right. Letter rogatory through Chambers. Okay. And then...
I'm going to do it by notary presentment also.
By notary presentment?
Yes. I got to create a record that I sent, so that I got some kind of evidence that they can't say, well, it just disappeared. I don't have any record of it.
Right. Okay, I follow that. And then one question relating to my my immediate mortgage case. When because I'm going to start filing docs this week and next week, so that I don't lose the plot here. I'm going. Naturally, I'm the grantor in all the deeds of trust that are in place right now. I'm going to be basically restating or re-expressing that trust and restating that I'm going to be grantor and beneficiary. In the interim, should I be sending notice of interest to the existing trustees of this mortgage who represent the beneficiary? Because there's about 4 of them.
Well, I would say fire them all.
Okay.
But I would make sure that I've claimed the one trust in the county, because that one's got you construed to be the trustee.
I'm sorry, say that again?
I would take care of the one that's in the county, because that's the one that's got you construed as being the trustee, and that's the actual evidence that they're using.
The one in the county, meaning the deed of trust?
Yeah, your deed of trust. Yeah, because it's if you read your deed of trust, it says the previous owner is the grantor and you are the grantee, and a grantee is a trustee. And then you recorded this in the county. You formed this trust, and you're the trustee over this trust. And they're coming at you as being beneficiary, you and the bank, them and the bank. So you have to get rid of that one, because that one's got you listed as trustee.
Okay. And by getting rid of, again, don't mean to make it a silly question, but what do you mean getting rid of it?
Well, you have to change that, because that's prima facie evidence. In fact, that's more than that. That's exculpatory evidence for you that you are the trustee.
Okay, so okay, I see what you're saying. So as the grantor, I'm going to restate that.
Yeah, you're going to have to correct that deed that's in the county there, because the grantor was the previous seller, and it formed a successive trust. You're the trustee on it. They're the beneficiary of the county, in cahoots with the bank, and that one's got you listed as the trustee on it. And then when you sell the property, I'm going to be able to put on you become the grantor, and the next guy that buys it becomes the trustee on it, the grantee on it. So it's a successive trust.
Okay.
Got to get the.
Okay.
But that's the one that's holding the lien on the property. And the property is the building, not the land. That's a contract. You need to get rid of that one.
Got it. Okay, I may email you something. Thanks, I appreciate it, Christian.
Okay, I would read Federal Rules of Evidence, Rule 501, and 501 basically says, in the last sentence of 501, it says that we basically go by here in the federal by the state rules of evidence. So that means you got to go into your own local state and get your rules of evidence that comport to Rule 501 in federal. And here in Florida, 501 comports to Florida as 90.501, which is the general rule, through 90.510. But I keep on saying specifically you want to look at 90.506 in Florida here, whatever it is in your state, you've got to look it up. And 90.506 is privilege with respect to trade secrets. And trade secrets is going to be under the discovery of your own state. Here in Florida, it's Rule 1.280C7. It talks about trade secrets. And you're going to put a protective order over those trade secret information and restrict the information, the trade secret information, the CCI information, to be for, say, judges' eyes only in chambers. And then 90.507 is waiver of privilege by voluntary disclosure. So anytime you come into the public side of the court, you waive the privilege, the trade secret, by voluntarily disclosing. In other words, by talking about it. You can't talk about it in the public side. You got to object. You got to object, or you're going to waive it. So to preserve your information, you have to just give enough information to the public side, a notice that it exists, and an order to the court, a motion, for them to do an in-camera hearing, because I got discovery information that's protecting CCI trade secret information.
And the hearing. Okay, cool. One last thing, and I'm just going over my notes from last week. You mentioned something last week that really hit home about defenses, and I think this was either under Rules of Court. You called it out as 4.1503. Foreclosure mandates the note must be surrendered to keep it out of the stream of commerce, or it is considered an illegal conversion. Now, do you remember where that was in your Florida code, right?
Yeah, that was Perry versus Fairbanks Capital Corporation.
Oh, it was Perry versus Fairbanks?
Yeah, 888 South 2nd, 725. 727. Florida 2004,
2008. I'm going to look that up because that's part of one of my notices.
2004.
2004?
DCA. 2004.
Okay.
Perry
That's
versus
Christian.
Fairbanks Corporation.
Okay. We're looking forward to the seminar or seminar.
Say again?
I said we're looking forward to the seminar. Get us the info ASAP.
Roger.
All right, thanks. I'm done. Thank you.
All right. Well, Christian, thank you. That was our last time for our last call tonight. We do have a couple other calls that we want to jump on, but we need to cut it off here at 10 o'clock Eastern Time. Folks, write your questions down. We'll pick them up next week. Thank you, everyone, for participating, and especially Christian, thank you for taking time to educating our minds so that we can go out and take our power and control back. God bless everybody. Have a great rest of the week and weekend, and we will see you next Wednesday. Good night, all.
All right. Thanks, Matt.